Thanks, Alan. So we're going to move from our expert panel to Matt Hayes and Danielle Muhlman, who are going to give us some thoughts on scientific certainty versus legal burden of proof. And Matt's going to kick it off, and over to Matt.
Thank you very much. And so, you know, my perspective, I'm a civil litigator from New Brunswick, and am generally going to talk about the context of causation and proving causation and scientific certainty in the context of civil litigation, and I'll leave the regulatory and prosecution to my co-panelist and see if I can get this to work here, see how my science is. So here's the simple proposition, which is causation. The plaintiff must show on a balance of probabilities that but for the defendant's negligent act, the injury would not have occurred. And it's a very simple proposition, and it's the basis of all causation and all proof in certainly tort actions, and it's any damages type action. And so I don't think I need to say any more than that's the simple proposition. Now, with that, the Supreme Court of Canada, and I've just picked sort of the highlight cases, has had to restate or reinterpret, explain and revisit that same simple proposition about a dozen times over the last few years. And these are the sort of the big cases of revisiting that very simple proposition, because either it's not simple enough or the judges and the application of it is actually quite complex when you try and do it. Ettinger and Johnson is the most recent case, and you'll see as we go through these aren't necessarily environmental law cases. I'll try and tie that thread in as we go through. But these are medical malpractice cases. In the case of Clements v. Clements, it's a motor vehicle accident. Resurface is a products liability case. Athey and Leonetti is, of course, a motor vehicle case, and Snellenfeld is medical malpractice. And Cook and Lewis, which is, of course, the most interesting case, is hunters shooting into the woods. So the current formulation by the Supreme Court of Canada is best expressed in Clements v. Clements, and that was the plaintiff has to establish on a balance of probabilities, the onus is on the plaintiff, that the defendant caused the plaintiff's injury on the but-for test, and this is a factual determination. Exceptionally, the courts accept that the plaintiff may be able to recover on the basis of a material contribution of risk and that analysis, but without some exceptional circumstances, we should be looking at the but-for test. And it's important, and I'll just mention the facts in Clements and Clements. In that case, it was a motor vehicle accident, and a husband and wife were driving on their motorcycle. The vehicle was overloaded by about 100 pounds. So the two people on it, it was over the weight limit. They were driving through on a rainy day. The husband was at the controls and was driving 20 kilometers over the speed limit. Earlier in the day, the tire had been punctured by a nail, and there was a sudden deflation of that tire. And the problem that arose in the case was about scientific certainty and what accident reconstruction could tell us about that accident. There's no question he was over the speed limit. There's no question the bike was over the weight limit. The question was whether the speed wobble that eventually led to the motorbike tipping over could be proven with scientific certainty, or whether the contribution of that particular speed wobble was it the sudden deflation, and that would have happened anyway. And so the expert and the court rejected the explanation and said there wasn't enough scientific evidence about that speed wobble to be able to determine the result. And so that's the facts, and I'll revisit the scientific impossibility in a second. But I will explain the material contribution of risk of injury. And this is the Cook and Lewis case, and it explains, and it's the almost perfect example of when to use that material risk or material contribution to the risk. And in this case, two hunters fire into the woods at the same time, and the guy in the woods is hit by a bullet. And of course, the two hunters are standing there pointing at each other saying, it wasn't my bullet, and you can't prove it was my bullet that injured the person. And what the court said is, by both firing into the woods at roughly the same time, you both contributed materially to the risk of the injury to this person. And that's the limited type of circumstance where you have multiple parties and for some reason you can't prove causation on a but-for test. And that is, it's a very limited circumstance, I think, from the Supreme Court of Canada jurisprudence. And then we come to the decision in Snell and Farrell. And this, again, if you look at the cases on causation, and in particular, again, we're going to the legal burden of proof or causation versus scientific certainty. And Snell and Farrell, again, I'll just promote it. It's a great case out of New Brunswick, went all the way to the Supreme Court of Canada. In that case, Dr. Farrell, who was the ophthalmologist, started surgery on a woman's eye and put a needle in to put the anesthetic in and noticed a small bleed. Waited some time, about a half hour, and then started up the operation again. And so he's sitting there and he has the knowledge of what's going on with this woman's eye. It eventually goes to trial because the woman lost her eyesight, and it turns out one of the potential causes was that small bleed that had started at the beginning of the operation with the anesthetic. And continuing that operation was negligent. Now, what happened was the woman's optical nerve had atrophied. And so the judge, who was sitting there and facing contradictory experts, said, essentially, there are multiple causes, including a stroke that had nothing to do with the negligent behavior, which was continuing the operation. The muscle could have atrophied just simply because, and the reason she was having the operation was she had no sight in that eye because of cataracts, and that is one of the potential causes. So there were other causes that were potentially attributable, and the science couldn't tell which cause or what caused this. And the experts, and if you read the case, the experts aren't able to tell exactly which thing caused the atrophy. And what the court in Snell and Farrell is really talking about is that there's a pragmatic and robust approach and not a rigid approach to scientific certainty or to proving something. And what it is they're asking or telling the court to draw an inference, and you take the facts, and then it doesn't matter, frankly, that causation doesn't have to be proved with scientific precision. In other words, a judge, and this goes back slightly to the last panel, but a judge is looking at it, assessing the facts, and on a robust and pragmatic approach, regardless of scientific certainty, is assessing the evidence and finding the facts. And the judge is there to decide as between the two parties and not necessarily to accept or reject the science. He's there to make a decision. And so this is this is the quote from the Snell and Farrell decision, which is essentially causation need not be determined by scientific precision. It's putting it in front of a judge and allowing the judge to make a decision given all the facts. In that case, Snell and Farrell is also important in realizing, and the facts are important, in that the doctor continued the operation, and I'll put it this way, the facts in Snell and Farrell really allowed the judge to bring in a factual inference that the injury to the optic nerve was caused by that continuation of the surgery. And the doctor was then in the best position to disprove his negligence. And we're not talking, and the court's very specific about it, it's not a reverse onus, it's simply a factual finding of the likelihood of that injury. And it's not a shifting burden so much as a burden once the factual inference is there, the defendant in that case was in the best position to discharge his burden of disproving that that was the cause. And again, the legal or ultimate burden remains with the plaintiff, but in the absence of evidence to the contrary adduced by the defendant, an inference of causation may be drawn, although positive or scientific proof of causation has not been adduced. In other words, don't need the expert to prove it. If looks and smells like a case where the injury was caused by whatever it was, then the judge, without proof, at least on a scientific basis, can make that finding and still be reasonable. And so that's Snell and Farrell, and that is, it still goes back through all the Supreme Court of Canada case law on this to the Snell and Farrell decision. And then the maxim that the court was talking about applying is that all evidence is to be weighed according to the proof, in which it was in the power of one side to have produced and the power of the other to have contradicted. And so, and we'll talk about environmental cases in a moment, but here, if the factual analysis leads to an inference of causation, and whether it's competing experts, it's within the knowledge of the judge, looking at all the facts, looking at all the witnesses, and he can make that judicial finding of causation regardless of, or with the science in mind, but it's not not based on science. So in the battle of proving causation, the legal burden versus scientific certainty, at this point, the legal burden is winning. The other, and I talked about Clements versus Clements earlier and the facts in that case. This is a quote from that case, which is restating that same law, which is the law of negligence has never required scientific proof of causation. And they're reinforcing it in that Clements decision, which is the common sense inferences or the experience of the judge in assessing the facts of the case may suffice. That's not to say that expert evidence is totally ignored by the court, but proof of causation doesn't have to be along scientific lines. Again, and I'll just talk about the F.H. McDougall case, because I think that's an important case in assessing scientific evidence or credibility, or the onus and the reverse onus or the evidentiary burden in a case. Again, this is a sexual assault case, but it also goes to arson cases. It goes to every case. Now, there is only one burden or one standard of proof at common law in Canada, and that's on a balance of probabilities. So is it more likely than not? But in environmental cases in particular, or in technical cases where there are experts involved, whether that's medical malpractice or engineering, it's important to read the rest of that sentence and argue it appropriately, which is there are inherent probabilities and improbabilities that are inherent in the evidence. In other words, if you're proving, for example, contamination or toxic injury from contamination, you should present the court with the evidence of probabilities or inherent improbabilities. And so those are sort of the high-level Supreme Court of Canada stuff. And there's a lot of cases on it, but I chose one out of Alberta because I'm here. And in this case, it was the Ball versus Imperial Resources Limited case. And this is where there was a leak from a pipeline, and I won't go into the facts extensively, but there was a leak from a pipeline, and the Alberta Court of Appeal examines the analysis of Snell and Farrell and Resurface, which is the other leading case. And the quote is there, and I won't read it, but essentially the Alberta Court of Appeal allowed, in the case of a contamination of a herd of cattle, there was two competing experts, one a veterinarian that had treated the cattle, another one a toxicologist. My read of the case is that the toxicologist probably had a better resume for determining toxicity. But the judge, in assessing and making an inference on the facts, which it was up to the judge to do, didn't have to accept or reject one expert over the other. And it's important to understand that it's based on the factual analysis, and in that case, it wasn't the pure science that would rule. It was the judge's assessment of all the facts taken together based on the balance of probabilities. And so if you want to read a really good case in terms of applying the Snell and Farrell decision, which is really the analysis of Imperial Oil had the opportunity to test the water, it had the opportunity to test the soil, it had the opportunity to then respond at the time of the incident in such a manner as to disprove or prove the allegation. And so on the balance of probabilities, that decision went to the person who was claiming the cows were contaminated. So with that in mind, I'll give some practical, what I'll call application to this. The but-for test should be applied in what the court has called a robust and pragmatic manner and a common sense approach. And what does that mean? I think it means the judges, and this goes back to the last panel to some extent, the judges who have no scientific training have to use their common sense in assessing all of the facts and all of the evidence. The material risk test is exceptional and only used where fairness requires the application consistent with corrective justice is what the courts have said about that in the lower courts. And it's a very rare case that will attract the material risk test. So what does that mean? There is actually no need for a court or tribunal to use expert evidence. They can use their common sense, whatever that means. Causation can be inferred from the facts, not necessarily the two experts. The scientific or expert evidence can displace what I'll call the common sense, in that you have to educate the court, a judge, as to what the common sense really is by giving them the expert evidence, by giving them the toxicology, by giving them the evidence through experts that will educate them as to what the common sense should be. And the common sense inference should be rebutted if you're a defendant through proving it by scientific evidence or disproving that initial evidence. There's a great article, and there's a great article by, or it's actually a speech by Mr. Justice Binney at the Viscount Bennett Lecture, and it's reproduced in the Advocate Society Journal. It's available on Lexis and Nexus. There's a great article looking at science in the courtroom by Mr. Justice Binney, and one of the examples he gave was a Unilever versus Procter & Gamble case, where the judge was looking at a patent case involving bounce and whether the surfactant was in or outside the patent claim of one party. And it's a great example after a frustratingly long list of experts being called to testify about surfactants. The judge turned around in his decision, and the quote is there. Hopefully you can see it, but the quote is there, and it's really a questioning by the judge of what he is doing, because he is unschooled in the subject matter in front of him, and he is choosing between experts based on one of them having shifty eyes or a nice tie on. And then from there, he is asked to assess their demeanor and come to a conclusion as to what the expert is meaning. And there's cross-examination, and if you look at the case, there's cross-examination on both sides that is by excellent lawyers, including Mr. Justice Binney, I believe, who was counsel in that case. And at the end of the day, the judge concluded that it was the exercise in silliness to have him deciding that. And so that goes to the training of judges. In terms of the practical application that I'm seeing in my practice, it's the rise of the self-represented litigant or the expert litigant. Whether it's an admin tribunal, whether it's an energy board, whether it's a building permit case now, everybody has access to Google and therefore has access to research and scientific literature of all sorts. Whether it's fracking or wind turbines, any of the cases involving water contamination now, people show up with a ton of self-researched litigation ready material off Google from some university you've never heard of. And the problem with that is that a judge sitting there with his common sense approach, and quite often two experts, both of whom have used Google, are now trying to present that as something meaningful. And the other problem now, and I've experienced this in a couple of cases, is my iPhone. Well, My iPhone has a level on it. It has a decibel meter. It has a GPS. I can take a survey result with my iPhone. I've got animation and photo editors on my iPhone. I can do an entire pipe design calculation for a $1.99 app. I can do a roof truss design for $39.99. It's a little more expensive and a little bit more calculation heavy. There are now chemical analyzers that you can hook into your iPhone. And so we now have what I call the rise of expert evidence that is as reliable as the iPhone. And so hopefully a judge as the gatekeeper, and I think we'll hear about that this afternoon, will reject some of those issues. But at some point, the common sense approach is, I think, going to be actually, to some extent, looking at the credibility of the two sides and the app, which app is better, is going to be a real problem for the judges. So a couple of articles, and it's Science in the Courtroom, The Mouse That Roared. And if you want to talk about the solutions that Justice Binney talked about, there are some there, which is educating the judges, recruiting judges who have scientific backgrounds. Hot tubbing is looked at, and there's that article that's really quite good. And there's also Galileo's Revenge, which is junk science in the courtroom. And it's an excellent book on this topic. Thank you very much.
So, hello everyone. My name is Danielle Muehlman. In full disclosure, because I'm government counsel, I'm counsel with the Ontario Ministry of the Attorney General, Legal Services for Environment and Climate Change, but nothing I say here goes back to the Ontario government or Ministry of the Attorney General or Environment and Climate Change. They're all my own opinions. When Sarah asked me to speak, I assume the reason she asked me to speak on this topic is because my life for the past 3 years has been pretty centered on, to give full disclosure, I was counsel on Castonguay, so centered on Fly Rock, and defending wind turbine appeals. So a lot of my experience in this comes from that background. So we heard a lot from Matt, and we heard a lot from the previous tribunal panel about how to prove scientific certainty, what to do, whether it's good, whether it's bad, whether it's working, whether it's not working. And I realized as I really started to think through what I was going to do in this is that in many ways what happens is the legislature's figured out a way around that to a certain extent. And I'll tell you what I mean by that. There's a lot of environmental regulation. We all know that. There's a lot of environmental regulation that's very, very technical. Almost none of that ends up being disputed in a prosecution or before an administrative board when you issue an order saying to a company, do something, clean up that site, fix that problem. It's all centered on those core principles that are in every single, I know because I did Castonguay, we looked across the province and outside Canada as well, that's in every single environmental statute, which is don't discharge something, substance, contaminant, pollutant, whatever you call it. Almost all of them define it very broadly as everything, solid, liquid, gas, odor, vibration, noise, et cetera, into the environment that might cause an adverse effect. So Section 14 sub 1 is Ontario's Environmental Protection Act. It talks about contaminants, it talks about adverse effect. Adverse effect, actually Ontario has one of the, I would say, most expansive in terms of definitions of adverse effect. It goes from impairment of the quality of the natural environment for any use that can be made of it. That was the umbrella clause that was being argued in Castonguay, right down to loss of enjoyment of normal use of property and interference with the normal conduct of business. The reason I say that the way the legislature has gotten around it is because a lot of these things get around it. You think about natural gas. Natural gas is odorless, colorless, but what do we put into it? We put into it mercaptan. Mercaptan stinks like rotten eggs. So if there's a natural gas release, the easiest way to prosecute for that natural gas release is because people hated the odor and they had to go in their houses. They had a loss of enjoyment of normal use of property. So do we need an expert to get up and say what the impact of that natural gas at that level with those concentrations in that environment might have been? No, not if there were a bunch of people who ran in their houses and had to stay there for 3 hours because of the smell of rotting eggs permeating their neighborhood. So that's one way that the legislature has gotten around it. So do we always need experts? I think we don't always need experts because sometimes the legislature's gotten around it. If it looks like a duck, swims like a duck, quacks like a duck, Judges are going to accept that it does duck things, right? So, like I said, I was counsel on Castonguay. There didn't end up being a trial on this. It was an agreed statement of facts that was all about legal argument. But at the end of the day, I can tell you that the case didn't have any expert evidence. It didn't have any expert evidence because a piece of rock flying through the air had the potential to harm people, impair their safety, and potentially loss of enjoyment of normal use of property, which is an interesting one, right, in that case. So how could it have loss of enjoyment of property? Well, I can tell you that in that case, what didn't actually come out in the facts is that the rock that blasted through the house landed in the kitchen. The baby was sleeping 20 feet away in the next room. So there was impairment of safety potentially. There was also loss of enjoyment and normal use of property because they couldn't use their kitchen for a month because they had to repair the roof. But what do you do when you have to prove a subjective value, right? Can science come into that? Loss of enjoyment of normal use of property. Is that a scientific thing? I think most of us would probably say no, it's not, right? So did the fly rock event prevent people from sitting in their backyard and enjoying a barbecue? Some people might say yes. Some people might say it's a pretty limited time event. It really, they happen and they're done in about a minute. I'm not sure that I would agree that that was loss of enjoyment of normal use of property, or if it was pretty de minimis. So there's two ways that could be looked at. What about, as I said with the mercaptan case, what about odor? There are many odors, like mercaptan, the reason it's put in is because it's not harmful to human health, that are not actually harmful to human health. Compost odors from an industrial compost facility, we have problems with those in Ontario. Manure spreading. Do you want to sit near a stinky compost operation that's not operating properly, that has permeating the smell of rotting garbage odors for 3 days? Probably not. You've probably lost enjoyment of normal use of your property. What about in a rural area where there's spreading of manure? I grew up riding horses. I can tell you that the smell of horse manure brings back all kinds of good memories for me. Not so much for many other people, right? In rural areas, we have different standards than in urban areas, maybe. How do you prove that an odor was sufficient to cause an adverse effect? Well, I can tell you what I've seen in a lot of cases in Ontario, which is that we have environmental officers who will go out and objectively source and quantify the odor. They go out and they say, it was really bad that day. It was really, really bad. I wouldn't have sat in my backyard. And the judge, or in our case, we often have justice of the peace on our, who are not legally trained necessarily on our prosecutions, and they say, oh, well, if an environmental officer wouldn't have sat in his or her backyard, that's good enough for me, right? Believe it or not, there are actually people whose noses are calibrated to do odor units. So some of our environmental approvals in Ontario actually have an odor unit scale. When I actually break it down with environmental officers and with those experts, they say, yeah, well, I know they were meeting their odor limit by the nose thing, but it still really, really stunk, so we're going to charge them. And all the neighbors say it really stunk and it was really bad and they can't sit in their backyards. So that's one way of getting around it. Like I said, the situation might be urban or rural dependent, depending on what the odors are. What do we need to do if it's an industrial operation? Industrial operations, by their very nature, have discharges. They're often approved discharges, but we all know that things go wrong. So do we need to understand what exactly went wrong to prove that company A was the source of the discharge of pollutant X to the nearby river, resulting in fish kill? So the answer often from what I've found is no. You know that the pollutant came from that company. You know that it went into the river, and you know, hopefully, that there was at least one fish dead, because that makes it easy, right? But we have had cases where the responding company, the defendant, says, well, wait a minute, we don't know exactly what went wrong. We don't know exactly what the cause of that discharge was. We know that we discharged, but we don't know what the cause of the discharge is. So how can we put together a due diligence defense? And that's the Petro-Canada case out of Ontario from 2003. This went up to our Court of Appeal. And what the Court of Appeal said to Petro-Canada was, sorry guys, I don't really care. If you know the cause, you might be able to have a much better chance of proving due diligence, right? You can narrow your evidence, you can really focus in on what the issue is, and you can tell us what you did to prevent that. But if you don't exactly know the cause, then you better tell us that you tried everything to prevent everything that might ended up in that. There was an interesting case when I noted up the Petro-Canada case out of the BC courts called the Zelstoff-Selger Limited Partnership case. It's a 2012 case out of the BC Provincial Court. And I'll give you guys the cite to that if you want to write it down. It's 2012 BCJ number 309. And what was interesting about it, there was a lot of discussion. It was a pulp mill. It was about black liquor. If anybody knows the pulp and paper industry, it was about black liquor. And the company was of the opinion that this was weak black liquor that got discharged. The prosecution was of the opinion that this was black liquor soap. If you read the entire decision, I don't think there were any experts that testified. Maybe there were, I don't know any more about the case, but they certainly weren't mentioned at all in the decision. All it was company X employee testifying as to what his observations were, what he saw, and therefore what he thought it was. And the Crown brought forward other evidence that said in the past they'd had a soap one, and it looked like soap, and it acted like soap, but not exactly like soap of their last one, and so we think it might have been soap. And you can see at the end of the day, the judge says, yeah, I think it might have been soap too. But you know what, it doesn't matter because Petro-Canada says we don't need to know exactly what it was, we just need to know that it was a bad thing that came out of your company that caused a fish to die. So you have to prove due diligence based on everything. And I'm not satisfied that if it was a soap discharge, which is what I kind of think it was, even though I didn't have any expert evidence that I can tell from reading the decision, that you didn't do everything you needed to do. So you don't have due diligence. So I think judges really do use common sense, their litmus test that's in front of them. And so as a result, the prosecution, we like to go on prosecutions where we don't have to rely on competing expert evidence, because it doesn't always work. So like I said, governments recognize how difficult this is. They often do what's called have deeming provisions, right? So I know that they're in many different legislation. I just pulled the Ontario Water Resources Act. So the Ontario Water Resources Act prohibits the discharge of any material, which I think is not even defined, it's just anything at all, into water or near water that might enter water and might impair the quality of the water. And we had a number of decisions that they followed a lot of the Fisheries Act charges. We don't charge, by the way, in Ontario under the Fisheries Act because the OWRA so closely follows the Fisheries Act in this regard. And we don't do it because of this deeming provision. So the deeming provision was put into the Ontario Water Resources Act in 2005. And if you look down it, you can see that it has things like the material or derivative causes or may cause a degradation in the appearance, taste, or odor of the water. It's an aesthetic impairment. So maybe we don't know exactly what that thing did to it, but it turned the river pink. That's an aesthetic impairment. It had scumballs going down the river. That was the case with City of Hamilton that we had. Other ones are that a scientific test that's generally accepted for aquatic toxicity indicates that the material or derivative in diluted or undiluted form is toxic. So we don't have to prove that when it got into the river it was actually going to cause an adverse effect. We just have to prove that the material itself in a rainbow trout test called rainbow trout. That's an accepted aquatic toxicity test. So these are some ways that I think the legislature has gotten around the scientific certainty. They deem things in. Now I'll put on my other hat. So that was my prosecution hat. This is my administrative law hat. And like I said, what I've done a lot in the last 2 years, Sarah? 3 years? I don't know how long it's been. Is defended the government's decision to issue wind turbine permits. And these are my opinions. I think that it's right that you start from the proposition that the legislature got it right. The legislature looked at the science and they got it right. The Ontario Ministry of the Environment, in fact, every ministry in Ontario is required to have a statement of environmental values. They had to put them out in response to the 1993 Environmental Bill of Rights, and they have to update them. And one of the Ministry of the Environment is that the ministry uses a precautionary science-based approach in its decision-making to protect human health and the environment. It's an obligation on Ontario to follow that in every decision that it makes including statutes right down to, and we fought this and lost, right down to individual decision makers issuing orders or issuing approvals. So when a party chooses to challenge the fundamental basis of legislative provisions, the onus lies with that party. That's where it lies in charter cases. If you want to challenge legislation on a charter basis, it's the applicant or the appellant's onus. And most statutes that provide for that right of challenge also put the onus on the applicant, and that's the case in Ontario. So, like I said, Ontario, we've had a lot of wind turbine matters. We've had them recently go up to the divisional court, and it's under appeal to the Court of Appeal for challenges to the wind turbine stuff. Now, they're not challenging a specific case. They're not saying in this particular case, we believe this wind turbine will have an effect on this person because of a particular medical issue they have. What they're saying is the legislature got it wrong. The legislature got it wrong, and a setback of 550 meters and 40 decibels is not safe. And what the divisional court said is that the expert tribunals that we were before got it right. That they did not have before them expert evidence which seriously called into question the principle undermining the Environmental Protection Act's renewable energy regime, mainly those setbacks, and that they do not cause serious harm to human health based on the current state of scientific knowledge. That's what they said. They said, we presume the legislature got it right, and you need to disprove that on a balance of probabilities, but it's your onus. What about where there's competing scientific opinions? This is an interesting case out of the, British Columbia. It went up to the Court of Appeal in 2004. It was the fluoridation issue. Somebody seriously had issues with fluoridation of water. There were actually experts on either side. If you read the decision, it's a good decision, at least from what I can tell from reading just the decision itself, of a court getting into and really trying to understand the expert issues before them in the competing expert opinions. But at the end of the day, the Court of Appeal said the trial judge recognized that he didn't need to accept the mainstream view, the government view. He examined many of the expert reports filed by the appellant, which postulated health risks associated with public fluoridation. In the end, the trial judge found that many of the scientific studies were inconclusive or inconsistent with respect to the question of serious risk of harm posed by fluoridation, and he concluded that he should accept the evidence placed before him. So I think there are examples of cases out there where judges are trying to really understand the issues and understand the scientific issues. But at the end of the day, I'm not going to disagree with anyone in the room that says that if a government body comes forward and puts something before a court, they're going to get a lot of deference. And that may be right and it might be wrong, but I think that's the way that the court system is working now. It's one of the ways that judges and JPs and administrative tribunals fall back on things. So that's my pitch. I don't know, do we have some time for questions?
Yep, we have about 4 minutes. Any questions?
Here.
Alan's gonna grab it.
Great. Thanks. Great, thanks. Good. Good, thanks. Voila.
So I'll read this one. It says, no expert evidence for nuisance or odor cases, definition of adverse effect. If having to prove a discharge, and you could go by way of subjective complaints about the nuisance or expert evidence, and both are not a slam dunk, do you recommend trying to prove both? The answer is yes. We would put forward the evidence of both. We would have the company who was there, who was calibrated to be able to give you odor units, and we would put that before the court. And we would also put those subjective complaints of individuals before them.
The question is, or the request for comment is, proving sufficient causation between the harm resulting from climate change and the acts or omissions of federal or provincial authorities can be a more complicated challenge. Any comment on this? Proving climate change with respect to acts or omission of federal or provincial authorities, I don't doubt that someday we will see that, and it'll be a really interesting case. And I look at today the smoking litigation that's going on across the country, and proving causation in smoking in the U.S. cases, or proving causation in those cases is, to some extent self-evident now to us today that smoking causes cancer. 50 years ago, that was a hotly debated issue. And so proving causation for climate change, unfortunately, may wait till you start to see the actual effects. But proving the future of climate change is, I suspect, going to be difficult.
There's also a much more diverse set of perpetrators, right? Smoking is the tobacco companies mainly. Climate change is everyone, maybe?
Any last question? If not, a big round of applause to Matt and Danielle. Thank you.
Okay, we will move on then to our next presenter on international developments in environmental crime and enforcement. And this is Kevin Burefine, who's the Regional Director for Wildlife Enforcement in Alberta. Thanks. Kevin.
Good morning. I tend to talk quite softly, so I hope everyone can hear me okay. I was just having a conversation with my colleague during the break, and we're kind of wondering whether it's better to be the last speaker before lunch or not be the last speaker before lunch. So I'm unfortunately the last speaker before lunch. You'll also find me referring to a lot of notes in my presentation. The reason being is I can go off topic really easily and start telling stories. So I really want to keep myself on track for this presentation. I come with the regrets of Sheldon Jordan, who's the Director General of Wildlife Enforcement for Enforcement Branch for Environment Canada. Unfortunately, he couldn't make it, so I have taken his place. I've been with Enforcement Branch for approximately 20 plus years. I started in environmental enforcement and have moved into wildlife enforcement, and you'll actually see those delineated within these slides. Actually, we examine wildlife and what we call pollution enforcement somewhat separately. I want to talk a little bit about the trends in environmental enforcement, because international environmental crime, and keep in mind that this presentation is much about an international aspect. I'm going to relate it occasionally back to Canada, but there's always the overpinnings as sort of the international aspect to it. So some of the things I'm going to say may or may not apply to Canada. When we look at environmental crime in terms of trending, what we see are a number of things. We see the economic interests. Who is going to make money from it? And it's not necessarily making money by the sale, but it may be making money by the cost of doing business. There's also the social aspects for environmental crime. When you think about traditional medicines and how some folks believe in the value of traditional medicine and how that can make money is very important. And there's also this, what I would call sort of the passion aspect to it, the interest aspect, in which folks want that beautifully colored macaw. They think it's important to them, they want it. So those are sort of the aspects and how environmental crime is becoming trending upwards because of those three things. Typically when I do these type of presentations, I like to bring in props, what I call props. And I think it would have brought a lot of notice if I brought a 60-pound elephant tusk and walked down the hall. But I was gonna bring a prop that's about the size of my fist. And it's a rhino horn, a black rhino horn. And I was going to bring that to show basically how, when you're talking about economic value, social impacts, and passion, how that rhino horn sort of represented just in the size of my fist. In itself, that rhino horn has a lot of economic impact. And the reason I didn't bring it is mainly because of the economic impact. I didn't quite feel comfortable on second thought walking around with a rhino horn in my pocket that's valued at $60,000 to $80,000. So just the size of my fist, $60,000 to $80,000. But the social impacts of it as well. When you think about social impacts in terms of our room, this room itself, you think about that rhino and that rhino being shot and what that means to a lot of people. But you also look at the interest aspects of it. You're thinking about the hunter who actually went out there and actually paid for a hunt. Whether he's a poacher or not, we'll examine that separately. but an actual hunter who may have paid for that hunt. And that has to do with a lot of wildlife animals. So, sorry, I hope I can advance this. Yes. So when I talk about presenting recent developments in environmental crime, I'm talking about those trends. Conservation and economic risks, I'm going to sort of examine those a little bit. But when we talk about providing information to help ensure your clients are compliant with the law, what we're talking about here is providing a perspective to you, providing a perspective to you and eventually to your clients on what environmental crime is all about. I'm going to be focusing quite a bit on the Environment Canada aspect of this. So there's other departments that are also involved when you're talking about some of the things I'm going to be talking about, such as timber, where Natural Resources Canada might be involved. So those can be obviously examined separately, but I'm going to be looking also at wildlife and pollution and breaking those apart. So it's going to be hard for you to read this slide, but what I really want to do is a little bit of shock value in terms of numbers. If you look at some of the things here, timber in the black, fish, wildlife, waste, minerals, in terms of their crime economic value, timber, 30 to 100 billion US dollars. Now keep in mind the international aspect of that. I'm not talking primarily Canada. Canada may have a substantially less element than that. Minerals might be the exploration aspects or the extraction aspects that promote environmental crime in this case, but 12 to 48 billion US dollars. Fish, 11 to 30 billion US dollars. Wildlife, that traditional wildlife I was talking about, the rhino horn, 7 to 23 billion US dollars. On waste, 10 to 12 billion US dollars. But let's for a second step back and ignore the economic impact of that. Let's look a little bit more of the social impact. When you're talking about, and you're looking in the gray here, and I'm going to paraphrase this quite quickly, species extinction being one of the big ones. Changes in climate and climatic emissions or suppression of those emissions. Changing the rainforest obviously is going to change climatic suppression. Resource depletion, we're talking about minerals. Alteration and annihilation of ecosystems, how that impacts certain animals, and impacts to human health or livelihood. And the thought is that often you can separate those out, but you really can't. And interesting, I'm going to get on the story topic, so forgive me for 1 second. I was watching a documentary a little while ago that was talking about a tiger, a population of tigers in this area. It was a jungle type area. And the tigers themselves were actually man-eating tigers. They would go after the local residents. But the local residents held no ill will towards the tigers. And the reason was that the tigers sort of protected that area. No one would go in there, so there was no logging, there was no impacts. So the tigers themselves actually presented that sort of protection. So when we're looking at saving those particular tigers, you're talking about species extinction, you're talking about the tigers save that rainforest, so climatic impacts, resource depletion, no one would go in there to take away that rainforest, so there was no resource depletion. The ecosystem was obviously not being changed, and the livelihood of those particular people who lived in that area was not impacted because that jungle still existed. So you can see how they all sort of meld together when we're looking at impacts. But when we get to the center, the drivers is something we really have to talk about. And again, I'm going to bring this back. This is not all Canada. This is international scope. So, and that comes out in corruption. When we're talking about corruption, we hope that there's not much corruption in Canada, but it's known fact there's corruption in this world. An economic driver for that one is it makes it easy to conduct illegal activities. The economic factor may be for that individual person who's given some extra money to look the other way. That may be a minor economic factor compared to the fact that he allows somebody else to make a significant amount of money. Lack of good, robust laws. Again, international, I would hope that Canada has good laws. I know there's a few regulatory gaps, but That exists on the international scale as well, lots of regulatory gaps. And what if, I'm going to use, probably should put a disclaimer up first, but what I'm going to use is good intentioned laws. And laws that are out there with the idea that this is what we intend to do, but they can be so complex in terms of scientific aspect of it that you can't enforce good intentions. We talk also about one of the drivers being corporate crime, the cost of doing business. I know a number of years ago when I was an investigator, actually in Calgary itself here, it goes back quite a few years, I investigated and with the help of PPSC, convicted a company for bringing a product into Canada that Canadians wanted. Now, there was limits. You could bring that product into Canada, but you had to have special permits. You could only bring in a certain amount at a time. And they exceeded that substantially because they wanted to bring this product into Canada. So they were convicted. They got a $30,000 fine. But I thought after the fact that this company, what was their profit in terms of being able to meet the demands the Canadians had and not having them go somewhere else? What was the profit that I missed when I investigated and thought about it? And that's sometimes known as the cost of doing business. Their $30,000 fine may have been minimal to what profit they made by producing that product or bringing that product into Canada. And we've always got to keep that in mind in terms of the cost of doing business. Conflict. That's another one in these yellow areas. We've got to think about mostly anecdotal information, but there's information out there that crime will fund conflict. We've got information that suggests that groups in Africa will use wildlife crime because remember that $30,000 worth of rhino horn? That's how they fund some of their activities. Terrorist groups or other groups who are trying to change government, etc. That's how they fund their activities. So conflict can have some impacts of us. Lack of enforcement. And it's the old adage, you cannot put a cop on every street corner. It's as simple as that. But when we look internationally as well, it's tough to fight crime internationally. When you're talking about complex mechanisms to share information between countries that have dissimilar legal schemes, that information sharing is often what holds back us from effectively fighting crime. Demand, this goes back to the, I think we all learned this in grade school, the law of supply and demand. If there is supply and you have the money and you want it enough, you can obviously get it. That's just the way society internationally generally works. And the last one being organized crime. Where there is money, people will organize together to make a network to profit from whatever it happens to be. In this case, environmental crime. So let's take a look at this slide here. Again, I'm going to say it again, this is international in scope, not so much Canada because there would be some differences, but it's a comparison of traditional crime, the drugs, the electronic crimes, the illegal trafficking of light weapons, and human trafficking is not there, but those are the traditional bigger ones, with the costs of what actually environmental crime is posing to economies now, posing to a world scale. Illegal logging and trafficking is huge almost compared to drugs. The illegal fishing, wildlife trafficking, illegal trafficking of toxic wastes, it's all up there in those big numbers. And that was back to the other slide, some of those numbers in terms of how this affects global economies and how it's going to affect us and our children as things go forward. This slide is basically about environmental crime networks. And what it really is showing the traditional crime networks and environmental crime networks. And just to, I know some people probably have a problem seeing this, but destination countries are in blue, transit countries are in yellow, countries of origin of traditional illegal trafficking are in brown, and main country of region of origin of environmental related illegal trafficking is in sort of a greenish. I wanted to note that if you see that a lot of the networks are pretty close to the same. The source countries, when you're talking about wood and wildlife, you've got your Africa, your South America, your Eastern Asia. Whereas you go for electronic waste, North America, Western Europe, those are the source countries. Destination countries, typically North America, Western Europe, for a lot of stuff. But now, if you look at some of these, particularly China, it's actually double marked with colors. Because China has now has an emerging middle class that has money. So they're now actually becoming a destination country as opposed to being just a source country. And when we examine pollution crime a little bit more, you'll see that a little bit more. So I know it's quite a convoluted slide, but when we talk about legal frameworks and operations, we sort of see a little bit of a cycle forming. The legal frameworks themselves, you can see a lot of international obligations, obligations that countries have to protect each other. I like to call this, in my own terminology, is sort of reciprocal enforcement. This is where countries will say, well, I'll protect what's coming into my country from your country if you protect what's going into your country from my country. We see a lot of that in the wildlife trade. But you'll also see a lot through a whole bunch of conventions here. The CITES Convention itself, which is enabled by WPREDA in Canada. Montreal Protocol under CEPA, ozone depleting substance regulations. Under CEPA, transponder movement of hazardous waste. Prior informed consent under CEPA. Organic pollutants, London Convention. On CEPA, Fisheries Act. Migratory Bird Convention is enabled in Canada by Migratory Bird Convention Act. And if you see the cycle, so these legal frameworks exist, and then they promote what we call the operations. And there's sort of a separation there. This is the Interpol, the UN Office of Crimes and Drug, Environment Program, World Customs. That's sort of the, I would call it almost the information enablers. These are the folks that actually let us take information together and actually work towards meeting these legal frameworks and conventions. And then you have the on-the-ground enablers, the national local enforcement agencies. These are actually what we would call maybe the doers, the people who are actually enforcing environmental crime, catching the bad guy. So this cycle actually will work because as you develop your legal framework, it feeds into information exchange, which feeds into us actually catching the bad guy, which actually feeds back into the legal frameworks in terms of seeing if these legal frameworks are working and expanding upon them. So I mentioned earlier there's going to be two parts to the presentation. That was the introduction. I'm going to talk about wildlife trafficking, and then I'll go into sort of the pollution component as well. You'll notice March 3rd, World Wildlife Day, earlier this week. What I want to do when we talk about wildlife trafficking is think about the first world versus maybe the third world. Where we sit today, was mentioned a number of times, we all have iPhones in our pockets, BlackBerries on our hips. We have very much that global impact at our fingertips. We can look out at there and see what's happening. So when we see things happening globally, such as being exposed to something being killed in Africa, that impacts us socially. We see that. But I want you to contrast that for a second with the, I hesitate to use the word hunter, but poacher maybe, in Africa, who doesn't have access to that social media, doesn't realize that there's impacts beyond just his little neighborhood, and realize that, and I'm going to make up numbers here, he can make months and months worth of salary just by killing one rhino or one elephant. And he has kids to feed at home. And he has no idea that there's somebody in his next village doing the same thing, and somebody in the village to the north doing the same thing. He has no idea that all these people are coming together and actually endangering these animals, putting on the brink of extinction. So you can see the collective, us, we get that collective social media that, oh my God, another elephant died, versus him, he's looking at his individualistic needs, his need to put food on the table. And that's one of the things we have to combat. We have to go back to the source and make sure that person understands the implications of what they're doing. So wildlife trafficking in the spotlight. Wildlife trafficking, fourth highest grossing illegal activity after narcotics, counterfeiting, and human trafficking. So there is big money. The rhino horn that was the size of my fist was probably about 1/5 a rhino horn. A good sized one, actually. And that was $60,000 to $80,000 was the estimate we had given it. So you can imagine how much that whole rhino horn is worth. That's why I keep things very safely locked in my evidence room and don't carry them in my pocket. We have to think about the conservation impacts on many iconic species around the world, and that's where we have an advantage in first world countries, being able to look at it and knowing the big picture, reading the National Geographics. But I said I was going to bring it back to Canada occasionally as well. There's a Canadian concern. And link it back, looking at elephants, one elephant dies every 15 minutes at the hands of a poacher. And from the 1950s, we've gone down in elephant populations probably about 90% down. So what happens when the elephant is no longer available for ivory? People still want these things. People who may have different ideas of why they want it, but they still want it. You look north. You look at Canada's resources, the narwhal, the walrus. We're starting to see that come into trade. We're starting to see the pressure there. Now there's the legal aspect of trade, which is very important, but there's also the illegal concerns because people want often what they get if they've got the money to do it. We also have to look at traditional Chinese medicine. That rhino horn that I was speaking of, what they do is they have a tray, pretty well, an enclosed tray. It's got sort of like a sandpaper bottom to it, and they'll take the rhino horn, put a little bit of water in, and they'll rotate the rhino horn to get the powder, and then they'll drink it. They believe that, they strongly believe, Vinny, that this is a traditional medicine to cure various things, including cancers. So until that moves away, that strong belief from people, we're going to have trouble with some of these things. So back to wildlife crime being a Canadian issue. Sustainable and legal trade, that's very important to us. 70,000 jobs are linked to legal and sustainable wildlife trade, often in the north, Aboriginal locations, rural communities. But Canada gets its commitments, meets its commitments regarding biodiversity, wildlife trade, migratory birds, by ensuring that we're keeping that trade sustainable, by ensuring that we're enforcing our laws. But when you think about the Canadian iconic species, we'll talk about polar bear. We've seen an increase in value of polar bear hides substantially. In fact, of course there's market fluctuations, but we've seen them on average around $5,000 to $25,000, with highs in the $30,000 range for one polar bear hide. We've also seen wild ginseng, $3,000 to $5,000 for a root, and these grow in Canada. And this one will actually, probably most people don't know about this, gyrfalcon. Now a gyrfalcon can easily, a live gyrfalcon can easily go for 6 figures. I've heard anecdotal information of over $200,000 for a live gyrfalcon using the falconry. There's some Middle East countries that are very much engaged in falconry. It's a sport and a social status symbol. So they really want these animals. These animals are in Canada. We've got to be cognizant of that. So we've got the fur trade, we've got timber, we've got trade in plants and animals for medicine, we've got the pet trade. Those are all legal and sustainable. What we're out here to look for is some things that are illegal, and that's what we have to be really cognizant about. So you'll see since 2010, in the last close to 5 years, how many summits and decisions have come out internationally on wildlife trade. We're seeing a big change. We're seeing a big difference. One of the things I wanted to point to is the London Conference on Illegal Wildlife Trade. And what you can see here is a declaration moving to a commitment, in this case from Canada, and leading toward the future, the Kasani Conference. So there's a lot of interest in moving forward. I was going to explain some of our recent work in wildlife interdiction. However, I'm running a little short on time. Again, I got in stories, so I'm going to keep on going here. And if anybody wants to talk to me during lunch, I'll tell you a little bit about these stories, because those are the stories I didn't want to get into. Pollution crime. This is problematic because when you talk about wildlife crime, you've got that fuzzy little animal you could hold, or that beautiful, iconic white polar bear that you can look at. Pollution crime has a little bit different aspect of it. Sometimes there is no direct effect. Sometimes the effect is years down the road. It may be invisible today. So that makes it very concerning from our point of view. And it's often very much economic in nature. There's not that passion of wanting that beautifully colored macaw. It's very economic that somebody wants to make money. And often what it is first world countries having pollution waste that needs to go somewhere. And that's what we're going to deal with in the first slide, is hazardous waste. Trade in waste. Essentially what it is, you need to properly transport, store, and dispose of hazardous waste. But the cost to dispose in a first world country like Canada are pretty high. Whereas there may be remember international? There's other countries who are going to take it for pennies on the dollar in order to dispose it for you. There was a study that was done by Interpol and the links between organized crime and pollution crimes, using information on 36 closed court cases from various countries, including Canada, United States, and some European countries. Based on the numbers of individuals and organizations involved and the period and nature of criminal activity, which involves smuggling and fraud, their conclusion was formed that organized crime groups are actively involved in hazardous waste smuggling, driven by the high price of legal disposal. Somebody's going to make money. This one really highlights the need for international cooperation. Discarded electronic waste. This is actually a really good story when you think about it, that has the potential to go bad. The good story being is there's a cycle. You start with the raw material, it goes to the producer who produces a product, our iPhone, goes to the consumer uses it for hopefully more than an iPhone of a month or two, and it moves to the recycler. A good cycle, because that recycler sends the product back into raw materials. The problem is, and you've all seen in the National Geographic picture of an Asian child sitting before a waste pile with a hammer and some electronic waste. And that's where things go wrong. And that's why we have to ensure that when electronic waste is shipped to jurisdictions, that there are agreements, that are methods in place, that those countries are going to make sure it's used and disposed of or recycled in an environmentally sound manner. So very much, I mentioned that pollution crime is very much economic, but those economics have, when you think about that Asian child with the hammer, have very much impacts on society and individuals. We've all heard of the ozone hole. It hasn't gone, the issue hasn't gone away. When I first started in law enforcement 20 years ago, we did a calculation. This is when CFC's Freon. We did a calculation, buying some stuff in Calgary here, taking it to the southern states, Louisiana. One truckload could net a profit of $1 million to do it illegally. That's big money. Now that we've moved away a little bit from Freon, we've moved to HCFCs, which still contain the chlorine atom, which still is an ozone depleter, but has less ozone depleting potential. But Chinese companies sell that for $2.5 to $4 per kilogram. US around $30 per kilogram. One would think that's fine. It's trade. That's the nature of our business. People profit from trade. The problem is that there's limits to how much we want coming into countries, how much trade we want. But people don't want to, they obviously want to ignore those limits so they can make money. So what we're finding is smuggling of ozone depleting substances. False labeling. People label it what it isn't. because it's hard to detect. There's misdeclaration. They call it something it's not. They call it propane, where it could be a Freon type material. Fake recycled material. Virgin CFCs or HCFCs are much more controlled than recycled stuff. So they call it recycled in order to make sure it comes into the country easier. So, and it's actually virgin. Concealment. Having ozone depleting substances in a shipment that's totally unrelated, and who's ever going to find it? So capacity building. Just on a little story, when I did some work with Interpol a number of years ago in a former Eastern Bloc country, and we did some training on environmental crime and detection. And it was interesting to find how the information wasn't there to link the investigators and link the scientific people together to find out exactly how we can get these guys, how we can get the bad guys. It just wasn't there. So a lot of capacity building has been done. This manual, the Pollution Crime Forensic Manual, leadership from Canada in this case, and in development of this manual, basically how to deal with pollution incidents. Everything from evidence gathering, analysis, preparation, presentation of data to prosecutors, to the courts, instructions on the equipment needed. This type of manual is important as we look globally, and we have to ensure our colleagues globally are able to work on environmental crime. So in conclusion, it's a global problem. It has to have that information exchange, intelligence exchange, to make us be able to understand what's happening out there. People profit, companies, networks, organized crime profit economically, but people suffer because of this, and we have to recognize this. And we have to recognize we need to work together to ensure compliance. Going back to that single rhino horn, that man received, the hunter, poacher I guess you would call, a paltry sum for that rhino horn. And yet it sits in my office valued at $60,000 to $80,000. Somebody's going to profit from that, whether it's wildlife or pollution crime. So it's definitely a global challenge that really needs us to think globally. That's my presentation. Thank you for paying attention.
Any questions? Yes. Thanks. Let me get you. Yeah, need that. Thanks.
Going back to the source so they understand impact sounds good, but what alternatives are being developed to offer the source as to why another option is better for him, her? It's a good question in terms of, you can't just say to a person with a starving family that, well, there's better alternatives out there. You've got to offer them some sort of incentive. I can't speak to what incentives are being done. I'm the enforcement person, but I know there's incentives being done by a number of countries. In fact, some of the incentives from the enforcement side, maybe not so much incentives, but we're making sure folks are out there globally and internationally. I had an officer go to East Africa to train people, to train investigators to understand how to conduct investigations. That may not be the incentive for the individual person who may be committing the crime, but it's an incentive to investigators to get out there, understand the global impacts, and try and intercept these type of crimes. So I think there's probably, on a policy level, governments, particularly first world governments worldwide, recognize that they have to provide the incentives. And I'm sure there's a lot of work being done on it. As for me providing an answer, I couldn't tell you exactly what that work would be. Any other questions? Oh, one at the back.
One more. Great, thanks. Okay. The next question is on elephant poaching.
Main recipients or market is Asia, China particularly. What about education, or rather media campaign, showing panda bears being decimated in some way as elephants to change attitudes? Are you still optimistic about the planet's health? Yes, I am optimistic. Being that the fact that we're actually in this room together, that you actually invited Environment Canada Enforcement to come speak to you, gives me a lot of optimism, because there's a lot of people like us who are interested in this. We want to know what's happening, and we have the means to know what's happening through social media, through the internet, through Facebook. We have the means to know what's happening. So I think there's a lot more engagement internationally, globally, on what is happening out there. So the message is getting out. As places like China, we talked earlier about, are developing that medium income. They're starting to be engaged now, I would think as well, I would hope as well, because they now have the resources to actually access the internet. They actually see that fuzzy little animal, and that's so important. Those iconic messages are so important.
Any other questions? All right, well, I'd like to thank Kevin
Thank
for
you.
very good. And now I'll turn it over to Stuart.
Thanks very much, it's great.
Just going off agenda very briefly here, which is ironic because Sarah hates that. So I just wanted to take a brief moment while we're all gathered here together to recognize and thank our past chair, my predecessor, Sarah Powell, for the tremendous work she did as chair and continues to do, as you see in this conference here today. Sarah's dedication and hard work for the CBA is reflected in so many things, this conference being just one of them. Professionally, she's recognized as one of the leading environmental law practitioners in Canada, and yet she's much more than that. She manages all these accomplishments while still finding the time to shovel out horse stalls in support of her daughter Rory's equestrian passions. And it's very clear on talking to Sarah how important family is to her, including also her husband Stephen and son Zach. And last but far from least, Sarah believes in giving back to the community. You've seen that today in her encouragement of all of us making a small donation to the Alex. If you review her glittering CV, which I try not to do because it makes me feel inadequate, you'll see she's also on the board of directors of the Stop Community Food Centre in Toronto. So in recognition of all of this, the CBA and the section officers wanted to make a small gesture of thanks and gratitude to Sarah. We actually have two things. First, I'm very pleased to confirm the CBA has advised me it'll be making a donation in her name to the Stop Community Food Centre. Secondly, we wanted something for her. I have reliable inside information that Sarah's only weakness is high quality cheese. If you're going to have a kryptonite, sounds like a good one to me. So the CBA is going to send her shopping to what I'm told is a very nice cheese shop in Toronto. So please join me in thanking and recognizing Sarah Powell.